Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 19 September to 24 September 2022. In first important news, the Supreme Court has held that a larger bench judgment will prevail irrespective of number of judges in the majority. In the case of Mrs. Trimurti Fragrances Private Limited versus Government of NCT of Delhi, the Supreme Court has held that a judgment delivered by a larger bench will prevail irrespective of the number of judges constituting the majority. In this case, a constitutional bench has held that in view of Article 145, Clause 5 of the Constitution, concurrence of a majority of the judges at the hearing will be considered as a judgment or opinion of the court. In second important news, the Supreme Court has held that mere possession of sensitive information is not enough for proving the offence of insider trading. In the case of Securities and Exchange Board of India versus Abhijit Rajan, the court was looking into a few regulations of the Securities and Exchange Board of India, Prohibition of Insider Trading Regulations 1992. In this context, the court has held that merely because a person was in possession of unpublished price-sensitive information at the time go trading in securities, it cannot be held that the transaction becomes the mischief of insider trading unless it is established that there was an intention to take advantage of the information. In third important news, the Supreme Court has held that pension rules to be interpreted in favor of the employee when more than one interpretation is possible. In the case of State of Rajasthan versus O.P. Gupta, the court was interpreting Rule 25, Clause 2 of the Rajasthan Civil Services Pension Rules of 1996. In this case, the court has held that pension is a lifelong benefit. Denial of pension is a continuing wrong. This court cannot also be oblivious to the difficulties of a retired employee in approaching the court, which could include financial constraints. Financial rules framed by the government, such as pension rules, are capable of more interpretations than one. Then the courts should lean towards that interpretation which goes in favor of the employee. Lastly, the Supreme Court has upheld the constitutional validity of the Haryana Sikh Gurudwara Management Act of 2014. In the case of Harbhajan Singh versus State of Haryana, the Supreme Court has upheld the Haryana Sikh Gurudwara Management Act of 2014. The court has held that the Haryana State Legislature did have the competence to enact the 2014 Act. Further, the court has also held that this act is not violative of right of Sikhs under Article 25 and 26 of the Constitution, as the affairs of the Sikh minority in this state are to be managed by Sikhs alone. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.